Good morning, everyone. I'm Judge Jackie Powell, and this is First Appearance Court. Today, you're going to be told whether I have found probable cause to detain you, and if I have, we'll talk about release conditions. Today's not your trial date. It's not the day that you're going to plead guilty or not guilty. It's the day when literally I'm going to tell you whether or not I found probable cause. And because today's not your trial date, what I would say to you is that you may not want to say anything on the record about your case because everything in this courtroom is being recorded. I also need to let you know that in the courtroom, I have an attorney from the state attorney's office. I have an attorney from the public defender's office. Over at the main jail, there's also an attorney from the public defender's office. Also in the courtroom, I have confinement status. I have pretrial supervision, and I also have a representative from the clerk's office. And you'll know that all these persons are needed to make this courtroom flow effectively today. I have read all the probable cause affidavits that will come before me today, and I have made a determination as to probable cause, and unless I hear some argument otherwise, that's how we'll proceed, and then we will talk about bond conditions. So when I call your name, I'm going to ask you to walk up to the podium, and in order to speak with me, the attorney will show you that you have to turn the microphone on. Also, if you're represented by the public defender's office, they will speak on your behalf. You can let them know what you want to say to determine if it is something that you should say on the record. If you're represented by a private attorney, that attorney usually comes to the courtroom and will speak on your behalf. If your attorney's not here, when you come up, you can let me know who that attorney is. All right, so let's begin this morning, and we're going to begin with Tamara Moore.
North Broward, Your Honor. Good morning.
Good morning, thank you. Ms. Moore, you're before the court this morning for a misdemeanor capious matter. It's on a prostitution charge. What does Ms. Moore wish to do?
She would like to resolve this morning, Your Honor.
All right, yes.
Just to make you aware, she was in custody. She's been in custody since she was in custody at the time the case.
So this capious should not have been issued because she was in custody?
That's right, Judge. We talked about that, but Ms. Moore indicated she would like to resolve the case today anyway.
Okay, all right. All right, so state?
Yes, Judge. The offer would be withhold court costs HIV test.
Is that what you'd like to do, Ms. Moore?
Yes,
Withholding
sir.
court costs? Okay.
All right, Ms. Moore, please raise your right hand. Do you swear or affirm to tell the truth?
I do.
You can put your hand down, ma'am.
Oh, okay.
Ms. Moore, do you understand what's going on today?
Yes, I'm resolving my case. Resolving my case.
Okay, and is anyone forcing you to do so?
Oh, yeah.
Ma'am.
Where
Are you under the influence of drugs or alcohol?
Okay.
I am not.
Have you ever been treated for a mental or emotional illness?
Yes, Your Honor.
Are you taking any medications, or is there anything today that would affect your decision-making?
No, Your Honor.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
Yes, Your Honor.
All right, what plea do you wish to enter, Ms. Moore?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is withhold adjudication and court costs, and you must take a HIV test as well.
I have already where I'm at the North Broward Bureau.
Okay.
I was just hoping that maybe they could send a copy of that to the clerk's office, being that I am in custody.
All right. I don't know how that'll work, but as soon as you can, you should make sure that it is presented to them. Good luck.
No, thank you. Appreciate it.
Good luck.
Jennifer Jones. All right. Ms. Jones, there's a few of them. Ms. Jones, if you'll have a seat, I'll recall your case, okay? All right. And then the same is going to be with Simons. So let's go to Sheila Rupert.
Ms. Rupert is your North Broward, Judge.
Okay.
Your attorney.
Ms. Rupert, good morning. Ma'am, you're before the
Good morning.
you're before the court today for committing theft and resisting recovery of property. And the court does find probable cause.
Judge, I'm going to ask the court to consider releasing Ms. Rupert on her own recognizance. She has been a resident of Florida since 1987. She's living at the same location for the last 2 years. She was a restaurant manager for the last 2 years, and as I understand it, she has no prior arrests.
That guy talk, unless you talking to him.
All right, I release Ms. Rupert on ROR. All right, ma'am, you'll be released on your own recognizance. You need to pay attention to the mail so you know when you have to come back to court.
Thank you.
Elizabeth Black.
No problem, John.
Yes, Judge.
What's going on?
Ms. Black, you're before the court today for 1 count of grand theft auto, and the court does find probable cause. Does the parties wish to be heard as to bond?
Judge, may I ask the court to consider pretrial release for Ms. Black? I think her prior contacts with the criminal justice system, from what she tells me, are of a relatively minor nature. She has been a resident of Florida for the last 25 years. She does collect a pension, but she doesn't get paid for a while, so she's going to have to sit in jail until that money comes through. She does have family here. Her mother lives here. She also has some physical issues that concern me that I'd like to see her be treated by her treating physician rather than remain in the jail to deal with those issues.
Okay. All right, Ms. Black, you'll be released to standard pretrial supervision.
Thank you, Judge.
You're welcome. Heather Lewis.
No problem.
Ms. Lewis, you're before the court today for 1 count of grand theft. Count 2 is a misdemeanor capias on a petty theft charge where you failed to appear in court last November.
Okay.
The court does find probable cause. What does the parties wish to say?
Judge, I was going to ask the court to place, bless you, to place Ms. Lewis on pretrial release with a GPS monitor.
Your Honor, the state would object. She's already out on a pending theft-related matter. The only reason she got picked up on that warrant for failing to appear in court is because she was committing a felony. She was arrested on a warrant for a new felony theft.
No way.
Property wasn't recovered in the felony case. And she has a prior from 2008 strong-arm robbery with battery.
Well, Judge, she has been living here for 18 years, the last 15 with her mom and dad. Her dad has some physical health ailments, and her mother is elderly, so it's difficult for them to take care of each other. She is a person who takes care of her parents. She's been a bartender for the last 3 years.
She also uses aliases Penny Bolt, Jane Doe.
All right, I do find probable cause. Ms. Lewis is out on a petty theft, failed to appear in court in November, and is now before the court on allegations of grand theft. And so, with all of that in mind, I am going to leave the bonds in place. Count 1 is $1,000. The misdemeanor capias, the bond is $250, and you will be before your misdemeanor court judge tomorrow at 9 a.m. Good luck, ma'am.
Thank you. I can at this point bond out if I had when I do get paid at my job.
There, you have bonds in place, yes.
Okay, thank you, ma'am.
I'll call your
Thank
mom.
you. Okay, thank you.
Tina Lydell.
No problem.
Ms. Lydell, ma'am, you're before the court for 1 count of resisting officer with violence, and count 2 is neglecting child without great bodily harm. And the court does find probable cause. What does the parties wish to say about bond?
I'm going to be requesting a $1,000 bond on count 1, $10,000 bond on count 2, an order of no victim contact with either of the children listed in the report until further order of her assigned judge in this matter. I have great concern not only for Ms. Lydell's well-being, but the well-being of her children based on these allegations.
I share the state's concern, and I think the court's very concerned too. It's very, very alarming probable cause affidavit. I have spoken with Ms. Lydell. I've also spoken with her life coach, who indicated to me that, well, let's suffice it to say that I think releasing Ms. Lydell at this point probably would not be in her best interest. I'm going to ask the court to set the bonds in place. We are going to be looking into Ms. Lydell's case and make sure that she gets whatever help and treatment that she needs.
All right. Yes, I do have great concerns also, both for you, ma'am, and your minor children. So I do find probable cause, and your attorneys will be working for the proper resolution on this case. So at this time, I will impose a bond on count 1 of $1,000 and on count 2, $10,000. Good luck, ma'am.
And Your Honor, as far as contact.
And no contact with the minor children until further order of the court. Take care, Ms. Lydell. Erica Lovesmith.
Yes.
Ms. Lovesmith, you're before the court for 1 count of possession of cocaine, and the court does find probable cause. That's the bond.
Judge, I'm going to be asking for pretrial release. I know that this is not Ms. Lovesmith's first contact with the criminal justice system. However, she has been an 11-year resident of Florida. She has a friend's house that she can stay at. She's been doing work for a nonprofit research studio for the last 4 years. She does have ties to the community. She's provided me with the telephone number for her sister. She does not think her sister is in a position to post bond for her.
Your Honor, I'd be objecting to pretrial. Ms. Lovesmith has an extensive criminal history. She was arrested in April of last year for violating pretrial. Judge Duffy placed a no bond warrant on her. Just have one moment. I'm just checking to see what the basis for the violation was. That was also on a drug-related case. Okay. Part of her pretrial, she was ordered to go to First Step Sober House. She absconded and just left there, and pretrial had no idea where her whereabouts were. So I don't have much confidence she'd be able to comply.
All right. I do find probable cause, and I am going to impose a bond of $1,000 at this time. Good luck, Ms. Lovesmith.
Thank you.
Vera Anderson. Okay.
She's here present, Judge, at Maine.
Thank you. All right. I'm gonna have to ask this detective to stop handwriting reports. Vera Anderson is before the court for 1 count of trafficking cocaine, 20 grams or less than 200 grams. And the court does find probable cause. As to bond.
Your Honor, I'm requesting that the court keep the $15,000 bond in place. I believe that is a reasonable bond, considering Ms. Anderson faces a 3-year minimum mandatory prison sentence if convicted of this charge. Also, just based on the amount of drugs and money involved in this matter, almost 57 grams of cocaine, in exchange for $2,100.
Okay.
Judge, we're going to be asking for the court to consider a bond reduction from $15,000 to $5,000. My understanding in speaking with Ms. Anderson, at this time she's not working. She's a stay-at-home mother. Basically, she's supported by her boyfriend, and also she receives disability for her daughter. Right now, Judge, she's been living in our community for the past 8 years. She's been residing at a location in Hollywood in the same apartment for 2 years, and their monthly rent is approximately $1,300 per month. Now, she has no money in the bank. She owns no property. Judge, my understanding is she's a registered voter here in Broward County, and she has a clean record here in Florida. Judge, she believes she does have friends and family that live in our community she's going to be reaching out to. She believes if the court were to consider reducing the bond $5,000, that maybe she can get her friends and family to come up with that amount, and that's why we're requesting a $5,000 bond on her behalf.
Okay, based on the circumstances in this case, I do find probable cause, and I do believe that $15,000 is a reasonable bond on this trafficking charge. Good luck, ma'am. Rebecca Crow.
Paul Ryan, Your Honor.
Thank you. Ms. Crow, you're before the court today. Is it an add charge? There's an additional charge for grand theft, and the court does find probable cause as to bond, or what is the status of the other counts?
She has no bond holds on counts 1 and 2.
Okay.
I just asked you to leave a bond on this case.
All right, so I do find probable cause, and the bond is $1,000. Good luck, Ms. Crow. All right, so municipal ordinance, we'll recall, and then let's go to Paul Main. I skipped 2, and we're at Paul Main. Mr.
Is
Main.
here present, Judge, at Maine.
Mr. Main, you're before the court today for a misdemeanor CPS matter on a possession of drug paraphernalia. What does Mr. Main wish to do?
Judge, in speaking Mr. Maine, he wishes to resolve this matter today.
Okay. And State, do you have an offer for Mr. Main?
I'm served, Judge.
Mr. Main, do you wish to resolve your case with time served?
Yes.
All right, so
Yes.
please raise your right hand.
Story?
Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Do you understand what's going on here today, Mr. Main?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
Mr. Main, do you understand you have a right to go to trial, that by taking a plea today you're giving up that right?
Yes, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea it could subject you to immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Main?
No contest.
All right, Mr. Main, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence, sir, will be adjudication and time served. I'll give you 6 months to pay your court costs. Good luck. Then we have Redan Harvey.
He's here at Maine, Judge, approaching.
Order him again. Order him. Yeah, that's not
Mr. Harvey, you're before the court today for 1 count of possession of cannabis, 20 grams or less. And the court does find probable cause. What does Mr. Harvey?
Judge, in speaking Mr. Harvey, he wishes to resolve this matter. We're going to see if the state has an objection as far as offering a withhold judicial notice.
I do not.
All right, so Mr. Harvey, if you want to resolve your case, it'll be withhold adjudication and court costs. I'll take judicial notice of any time served.
He wishes to accept the state's offer.
All right, Mr. Harvey, please raise your right hand. You swear or affirm to tell the truth?
Yes.
You can put your hand down, sir. Do you understand what's going on here today, Mr. Harvey?
Yes, ma'am.
And is anyone forcing you to resolve your case?
No.
Do you need more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
And do you understand, Mr. Harvey, you do have the right to go to trial, but by taking a plea today, you're giving up that right.
Yes.
And do you understand that if you're not a U.S. citizen, that by taking a plea, you could be subjected to immigration changes?
Yes.
What plea do you wish to enter?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence, sir, will be a withhold adjudication and court costs. I'll take judicial notice of any time served. Good luck, sir. And I will recall, I'll put this on hold, Odom, and then I'll put Dyson on hold, and Kennedy I'll recall, Marapi I'll recall, Purcell,
Marapi, I believe, Judge, is maybe a state offense.
is it? Okay, hold on. All right. Yes, it is. Tendai Marapi.
He's approaching, Judge.
All right. All right. Mr. Marapi, we're back in a familiar place. You're gonna let me start singing that song, because, you know, when I see your name and I see your face, I know who you are. That's not good. What does Mr. Marapi wish to do?
Mike's off.
Oh, your mic's off, Mr. Romero.
Oh, I'm sorry. Mr. Marapi wishes to resolve this matter today, Judge.
Your Honor, frankly, I'm not sure really what even to offer. This is his 6th arrest since January 31st. He keeps getting time served, and the court requests that he stop this, but he's not.
Yeah, that is my concern. But, you know, it is a second-degree misdemeanor, and
Understood, that's why
there's only so much that this court can do at this time. So, my offer at this time would be adjudication in 5 days in the Broward County Jail.
Let me talk to him, Judge. Judge, he wishes to accept the court's offer.
All right. Mr. Rapi, please raise your right hand. Do you swear or affirm to tell the truth? I don't know if
I think you cut out. I think you cut out, Judge.
Do you swear or affirm to tell the truth, sir?
Yeah.
Okay, you can put your hand down. Mr. Morape, do you understand what's going on here today?
Yeah.
Is anyone forcing you to resolve your case?
Nope.
Do you need more time to speak with your attorney?
Nope.
Are you under the influence of drugs or alcohol?
No.
Do you understand, sir, that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
Yes.
And then what plea do you wish to enter, sir?
No contest.
All right, Mr. Marape, I accept your no contest plea, find that it's freely and voluntarily given. Your sentence serves adjudication in 5 days in the Broward County Jail. And my advice to you would be to try and see if you can find help at the shelter or something, so that you're not before the court every other week for these charges, these types of charges. Do you understand, sir?
Yeah.
All right, good luck, sir. I'll put Mr. Cressel at the end.
And Mr. Cross, I believe it's a state offense. Well, yeah. It's another panhandling, but I believe they charge it as a state offense, Judge.
All right, Herbie Cressel.
Hello, Your Honor.
Hello, Mr. Cressel. You also will have me singing in a moment. Here we are again, old familiar place, where the winds will blow. No one ever knows time or space. We've got to stop singing that song. Why are you here again?
I've spoken to my father,
Yes.
and he has agreed to take me back home. I was just trying to come up with half the money for the bus fare. But with this happening, I'm going to call him down. I'm going to tell him he has to pay the whole thing.
All right. What do you wish to do today?
I want to handle the case and go home, man, in Tampa.
All right. State.
It's off for his 5 days, like Mr. Marapi was received. This is his 4th arrest this year, 13th arrest in the past year. And Mr. Cressel, it's the same thing every time. There's an explanation for why he did it. He's starting a new job tomorrow. Now he wants to go get bus fare to move. And yet we always end up back here, so.
All right, Mr. Cressel.
They're aiming after us homeless people.
Well, you know. Well, to resolve your case is going to be adjudication in 5 days. Do you want to do that?
Judge, Mr. Cressel, I believe in speaking to him. He first wanted me to ask the court if the court would be inclined at this time to ROR Mr. Cressel.
No, that's not going to happen.
Okay.
So what do you like to do, sir?
Try the case.
Judge, Mr. Cressel informed me right now he wishes to resolve this matter today.
All right, Mr. Cressel, I'm not trying to force you to resolve the case, but you've been back before me several times now, and so that's the offer. So you don't have to resolve your case because you feel pressured, but I'm telling you that I'm not RORing you. So do you want to resolve your case?
I mean, is there any other way to be released?
Not to pay your bond.
No.
All right. Then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right. Is anyone forcing you to resolve your case, sir?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you understand you have the right to go to trial, that by taking a plea today you're giving up that right?
Yes, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to immigration changes?
Ma'am.
What plea do you wish to enter?
No contest.
All right, Mr. Cressel, I accept your no contest plea, find it's freely and voluntarily given. Your sentence serves adjudication in 5 days in the Broward County Jail. Good luck, sir. Credit for any time served. All right, Gloss is a MO case, right?
Correct.
All right, so we'll go to Alvin Jackson.
And Mr. Jackson is approaching, Judge.
Mr. Jackson, you're before the court for a misdemeanor ordinance matter on a petty theft case.
Mr. Holcomb?
This is an old warrant from 2012, it looks like. What does Mr. Jackson wish to do?
Judge, and speaking Mr. Jackson, he wishes to resolve this case today.
Offer from the state to withhold court costs.
All right.
He wishes to accept the state's offer, Judge.
All right, Mr. Jackson, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. Mr. Jackson, do you understand the proceedings you're in today?
Yes.
And is anyone forcing you to resolve your case?
No,
No.
Do you need more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
You understand that you have the right to go to trial, that by taking a plea today, you're giving up that right?
Yes, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Jackson?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given, and I sentence you to a withhold adjudication and court costs. Good luck, sir.
Yes, sir.
Chad Traniello.
Mr. Treniello is here, present, Judge at May.
All right, sir, you're before the court today on a misdemeanor KPS matter for a DUI with property damage and DUI. You failed to appear in court September of last year. The bonds that were imposed by $500 on each count. So,
Judge, we're going to be asking the court to consider an ROR on Mr. Treniello's behalf. My understanding is the day the KPS was issued, he was in custody, I believe, in Orange County. So it's our position that he didn't voluntarily miss court. So we're going to be asking the court to consider an ROR on his behalf.
Your Honor, well, first off, if he got himself arrested in another county, that's really on him. Two, this KPS was from September of last year. I mean, where's he been? And I would also note this was for a change of plea.
well, it looks like he was arrested in Lake County, or he was in Lake County.
He was
Jail.
extradited
Brought
down
him
here,
from
Judge.
Well, no, I don't, but if I could have one moment. I don't know that that was, I don't know that he's been in jail this whole time.
He's been in custody, Judge, for the last 6 months.
Okay.
The only arrest I see was prior to this. He was arrested September 20th by the Winter Garden Police, which is Orange County.
All right.
He was taken in Lake County, so it wasn't as though he was been in custody. He was obviously out of custody from Orange County to be arrested in Lake County on this warrant.
All right.
Judge, I can only go by what Mr. Treniello advised me. He's been in custody since September, and he was brought down here. Oh, Orange County, Lake County.
All right. I am going to release him on pretrial, standard pretrial supervision. That's what I'll do at this point.
And Judge, good morning. I'm in the main jail. I'm the next person
Go ahead and basically
after Mr. Treniello.
jail to pre-trial.
Okay. So Cedric Jean-Pierre.
Yes, Judge, he's here. Jean-Pierre.
Yeah, go.
Sure.
All right, Mr. Jean-Pierre is before the court for one count of resisting without violence, and then there is a misdemeanor KPS on a municipal ordinance matter.
Same page.
Another. Oh.
I do find probable cause as to count one. What does Mr. Jean-Pierre wish to do?
Judge, in reference to count one, and speaking with Mr. Jean, all this matter today?
It's the same as the count two, Judge.
All right, state.
The time served on count one.
All right.
Judge, in speaking with Mr. Jean-Pierre, he wishes to accept the state's offer.
Yes, yes.
All right. If he wants to resolve the municipal ordinance matter, it will be a withholding court cost.
The judge said withholding court costs. You wish to accept that?
Yeah, that's good.
Tell the judge yes.
Yes.
All right, Mr. Jean-Pierre, please raise your right hand. Do you swear or affirm to tell the truth, sir?
Yeah.
All right.
Yes.
Do you understand what's going? You can put your hand down. Do you understand what's going on here today?
Yes, I'm getting released.
Okay. Do you need more time to speak with your attorney?
No.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
It could subject you to deportation by taking a plea if you're not a United States citizen.
I'm a citizen.
Okay, sir. What plea do you wish to enter?
No contest.
All right, Mr. Jean-Pierre, I accept your no contest plea. Find that it's freely and voluntarily given. As to count 1, your sentence will be adjudication and time served. On count 2, it'll be withholding court costs. Good luck, sir.
Thank you, Judge.
You're welcome. Brian King.
Mr. King is here present, Judge at Maine. He's approaching. Come on up, sir.
Mr. King is before the court for 1 count of misuse of 911 system. And the court does find probable cause. Does the parties wish to be heard as to Mr. King's case?
Judge, we're going to be asking the court to consider releasing Mr. King, ROR, on pretrial release. He's 62 years old, been here his whole entire life. He got Social Security. He's on a fixed income. He lives in Fort Lauderdale by himself. Location for about 15 years is what he informed me. So, Judge, we're going to be asking for the court to consider releasing him on pretrial release today.
I would ask the court to consider keeping the bond in place and transferring the case to Judge Lerner Wren's division. I can tell you, while it's been a little dated, Mr. King does have a history of mental health issues, both in Broward. He has a prior Baker Act in Orange County. The nature of this offense, the allegations, and the nature of this offense in general has given me some concerns about his mental health.
I also have some concerns reading the probable cause affidavit, so I will sign an order to transfer this case to Judge Lerner Wren's division. That's what I'll do at this point in time.
If you like, Your Honor, I can let her judicial assistant know.
Yes, please. All right, good luck, Mr. King. You'll see another judge with this case. Joseph Sullivan Smith.
He's approaching, Judge.
Mr. Smith, you're before the court for 1 count of DUI, and the court does find probable cause, as the parties wish to be heard.
Yes, Judge. This time, financially, no one's going to be able to afford to post his bond. He works off and on in roofing. Unfortunately, at this time, he is homeless, Judge. He's 31 years old. He does have a mailing address where he can receive notices, Judge, but at this time, he has no one to post his bond, so we're going to be asking Mr. Sullivan to be considered to be released on pretrial release.
One moment, Your Honor. I'm showing that Mr. Sullivan Smith has a warrant out of, looks like Rhode Island, from January 24th of this year for a failure to appear at arraignment for a felony assault and or battery. It's only extraditable from Rhode Island and Maryland. But I do have a concern that it's an example of failing to go to court. I'm also showing failure to appear out of Rhode Island 2016. He's got a prior DWS. He's got a prior DUI out of Rhode Island from 2015. Frankly, based on a second DUI and a pending warrant, I would object to pretrial as well.
All right, I find probable cause and Mr. Sullivan's bond will remain in place at $500. Good luck, sir. All right, Brian Wetzel,
Bonded.
all right, I'll recall Cade as well.
Judge, I believe Mr. McCoy.
Good morning, Judge.
Oh.
Mr. Cade is here.
All right, Mr. Cade, you're before the court for a count of municipal ordinance, and Mr. Cade is another person who'll have me singing "Here We Are Again." I don't know what the resolution is at this point.
Judge, I'm unaware as to when Mr. Cade was last here. So
I've seen Mr. Cade about 3 times, at least 3 times now since I've been in first appearance.
2 weeks ago.
And there's a time before I gave him 5 days in a county jail, and then I think he came back after that. So 2 weeks ago was the last time he was here. At which time, when I gave him 5 days, he told me he didn't know that it would be so much time on a open container. So I don't know what to do at this point in time.
Judge, would in speaking to Mr. Cade, Judge, would the court consider a 5-day jail sentence with no return to the property, which is the 7-Eleven on West Broward Boulevard?
I think that was the same place and the same sentence last time.
He claims it was a different city, Judge, last time.
Nope. I remember. It's not. So what kind of, does he want to go to a program or something? Because, you know, I don't want to keep sentencing him every time he comes to first appearance, but I'm left with no choice. If he wants to resolve his case today, it's going to be adjudication in 10 days.
Judge, Mr. Cade indicates to me he'll accept a 10-day jail sentence. Yeah.
All right, Mr. Cade, please raise your right hand. Do you swear or affirm to tell the truth?
Yeah.
You can put your hand down, sir. Mr. Cade, do you understand what's going on here today?
Yeah.
Is anyone forcing you to resolve your case?
No.
Do you need more time to speak with your attorney?
No.
Do you understand that you have the right to go to trial, that by taking a plea today, you are giving up that right?
Yeah.
Judge, could I have one moment, just one minute?
Sure.
Judge, and speaking to Mr. K, Judge, I'm not sure what his prior record is. Perhaps the state can help. I don't know if he has any prior violent offenses, but if he doesn't, he would qualify for the community court. If he does, he wouldn't qualify, and that's an option that we could try.
Mr. Linder, can you help with, okay.
Not seeing anything violent as far as Broward goes. Frankly, I don't know what his history is internationally.
All right, as far as Broward, there's nothing. So do you want to, we'll transfer him? I'll be happy to transfer him to community court.
Judge, that might be an option. If the court is willing to entertain that option, we could try that as a last stop.
All right, so then let's try and get that done then.
Okay, so I'll bring the order to the court. Okay. So he'd be ROR, Judge?
Yes.
Or, okay, all right, thank you, Judge.
Is that, wait, is that how it's done? I don't remember what Judge Barner told me.
We don't have the...
He has to be out of, yes, he has to be out. So we have to bill our arm and you'll transfer to the community court.
Okay, I thank you, Judge.
Okay.
I give you information.
She knows she remember faces.
So someone's, on page 20, someone's signed in for Corey Butler.
Mr. Butler is here present, Judge at Maine.
All right. Mr. Butler, you're before the court today for one count of aggravated assault with a deadly weapon without intent to kill. And the court does find probable cause.
Good morning. Good morning, Your Honor. Nancy Hunnigan, Pretrial Services. He's currently on pretrial for case number 1-800-8878 CF10A for murder in the second degree with a deadly weapon. We're requesting his pretrial is revoked.
When was he placed on pretrial release?
Thursday, I think, if I'm not mistaken.
I'm sorry?
I think it was Thursday, if I'm not mistaken.
Thursday of last week?
No, Your Honor.
No.
November 5th, 2018.
Okay.
1 second. Let me just check. 1 second. Check.
November of last year, Your Honor. Mm-hmm. I would also note that case is before
the bond and pretrial?
Yes. Bond was set at $50,000 pretrial release with a GPS monitor. That case is before Judge Bober in Rock Court.
All right. I'm so... Ma'am, I would advise you not to say anything that relates to the case at this point.
Yes, Judge, I advise the young lady, she's best advised to speak to Mr. Butler's attorney.
Yes.
Which is either Maury Halprin or Terry Moons.
Okay. Please do that. As to case number 18008878 CF10A, Mr. Butler is out on pretrial release on a felony charge, and I am going to revoke the pretrial supervision. It's going to be set at no bond.
Your Honor, on this case, the state is going to be requesting a $25,000 bond. My concern is, while out on a charge of murder in the second degree, he's allegedly committing a violent offense. There's an independent witness. There's physical evidence supporting the allegations. He also has a lengthy history. In addition to this pending case, as obviously the court would be aware, since considering he qualifies for a career criminal court, he's been to state prison for possession of cocaine, delivery of cocaine, possession of cocaine, conspired to traffic cocaine, multiple other priors, Your Honor.
All right.
Judge, we're going to be asking the court on what the matter that's here before you to set a $5,000 bond. At this time, Mr. Butler, since he's been released, he's gotten a job doing landscaping. He makes about $110 per day. He's 41 years old. Right now he's living with his girlfriend where they're renting. They do not own their home. From what he advised me, he owns no sort of property, no sort of money. So from what the state is suggesting, he just financially can't post that bond. We do realize because of the court revoking his release on 18-878 CF10A, he's still going to have to appear before his division judge to get some sort of relief, but we're going to be asking the court to consider a $5,000 bond on this case, Judge.
And as to the new case, I do find probable cause. I'm going to impose a bond of $25,000.
Your Honor, I would just be asking for no victim contact as well.
And no victim contact. Thank you. All right, good luck, sir. Thanks, ma'am, for being here. Julian Howard.
Judge, I've been informed he bonded.
Okay. All right, Kenneth Johnson.
No problem, Your Honor.
All right, Mr. Johnson, you're before the court for 1 count of robbery by sudden snatching without a firearm. Count 7, robbery by sudden snatching without a firearm. 8, petty theft, first degree. And 9 is a felony violation of probation, which is a no bond hold. As to, I do find probable cause. That's the counts 1 and 2, and does the parties wish to be heard as the bond on count 1?
We're requesting a $2,500 bond on count. Charge 7, Your Honor.
Judge, Mr. Johnson indicated to me that he has resolved the violation of probation matter. Maybe confinement status could help us clarify that.
My notes indicate he should be in court on that matter tomorrow.
Your Honor, he did resolve the violation of probation on his felonies for the new arrest before this. Okay. He's now going to go in front of his judge on these new allegations, which obviously his judge was not aware of when his VOPs were resolved.
Right.
Yeah,
so
this incident seems to have happened on February 5th, which would have been before his probation was reinstated.
That has, Your Honor, I don't think that's relevant for these purposes. Your Honor, when he was first arrested, he was arrested on grand theft auto. There was a 94806 hold for his probation. He had another theft, and then a warrant was signed for his VOP. He has since resolved the VOP, but obviously his judge was not aware, Judge Merrigan was not aware of these allegations. For all we know, Judge Merrigan, upon hearing this, might say, you know what, I wouldn't have reinstated if I knew that there were these additional allegations. That's why he should really go before, frankly, he should go before Judge Merrigan, but it's just all of his charges, including the cases he was on probation for, and the new offenses that were the basis for his violation are all theft related.
So on count 7, at this point, I'll impose a bond of $1,000, and there's a $100 bond on the petty theft. And my notes indicate that on the no bond hold, he'll be before his felony judge tomorrow at 8:30. Good luck, sir.
You're going to have to wait till tomorrow, Mr. Johnson.
I just asked for an order of no return.
Is that for my? I thought the no bond hold was for the misdemeanor, man.
No, that's for the felony violation of probation.
He's also being held no bond on a misdemeanor VOP as well, but that's
I don't have that before me today.
Your Honor, I would just ask for an order of no return to the Seminole Coconut Creek Casino property.
Right, and sir, no return to the Seminole in Coconut Creek. Good luck, sir. Vincent Jean Hilaire.
Medical research, Your Honor.
All right. All right, how about Carl August?
Here, President, main judge approaching.
Mr. August, you're before the court today for, I'll just say it as one count of attempted murder. And the court does find probable cause.
Your Honor, he's currently out on pretrial for felony battery, great bodily harm, case number 18014307, CF10 and rule requested for pretrial to vote.
Argument from the parties?
Your Honor, I'm not going to be seeking a no bond hold at this time. What I am going to be requesting is a $200,000 bond. Should he be eligible for release at some point, pretrial release with a GPS monitor level 1. Your Honor, I would note I spoke with Detective Foster, who he didn't author. He is Detective Curcio's partner. He took a statement from the alleged victim, who advised once he regained consciousness that he was struck multiple times, pistol whipped multiple times by Mr. Auguste. I would note the case he's out on, the felony battery, great bodily harm. The victim he allegedly attacked suffered a fracture of the right orbital bone, contusion of his left shoulder. His nose was broke, and orbital congestion of the right lung. I would also note that Mr. Auguste, in addition to these cases, he pled out January 23rd of this year, a violation of a pretrial release condition, that being a no contact order. The listed victim in that case was Ms. Gurrier, who's referred to in this warrant. He's also, been, and Your Honor, I believe this is relevant based on the allegations here, was arrested for battery against her and violation of a no contact order against her, and those two cases were dropped.
Judge, what the state is suggesting is something just basically out of reach for Mr. August. He's 23 years old at this time. He is working. He works at PF Chang's, making minimum wage. He lives in Lauderdale Lakes with his girlfriend, and unfortunately his girlfriend is not working at this time. So financially, they are indigent. I'd ask you to take that into consideration in determining reasonable release conditions for Mr. August.
Okay, let's go with the first case. Mr. August is on pretrial supervision on case number 18-014-307 CF10A for felony battery. As to that matter, I am going to revoke his bond, and there's going to be a no bond hold as to that case. Mr. August is now before the court for attempted murder, allegations of attempted murder, and I do find probable cause. At this time, I believe that a reasonable bond on this case is $200,000. Mr. August is to have no contact with $200,000 with level 1 GPS. Mr. August is to have no contact with the alleged victim, Stanley Morissette, or Lovely Guerriere. He's to possess no weapons, and no contact, no weapons. I believe that's it. Good luck, Mr. August. Darwin Mingo.
Medical reset.
Okay. Ernest Merritt.
Approaching here, Maine.
Mr. Merritt, you're before the court today for one count of aggravated assault with a deadly weapon without intent to kill. Count 2 is touch or strike battery. Count 3 is a parole violation. The court does find probable cause. As to bonds.
Your Honor, I'm going to be requesting a $15,000 bond, considering that the level of violence alleged in this case, that he's on parole out of another state for trafficking heroin, and I would also note that he just pled out January 8th of this year 2 counts of threatening specified individuals. So obviously there's a concern that he's threatening violence against someone else, now before the court for threatening violence against this individual. I'd also be requesting an order of no victim contact.
Judge, we're going to be requesting a $5,000 bond on Mr. Merritt's behalf. Right now, unfortunately, he's unemployed. He's currently looking for work. He lives with his uncle in an apartment. Been residing about 1 year now. He says his uncle cannot financially afford to post a high bond. He has no property. He has no money in the bank. That's why we're requesting a $5,000 bond on Mr. Merritt's behalf.
When she I don't know if she went already.
All right, I do find probable cause. As to count 1, I am going to, I will impose a bond of $5,000 with a level 2 GPS. And no contact with the victim in this case. As to your parole violation, you will be before the parole board at the time that they set the hearing. Good luck, sir. Robert Sissel.
Approaching, Judge.
Mr. Sissel, you're before the court for 1 count of possession of cocaine, and 2 is a traffic habeas matter.
Your Honor, he's currently out on pretrial for grand theft auto.
It's okay, because you,
Case number 190015047
thank you.
CFT name. We're requesting his pretrial is
When was he placed on pretrial?
Your Honor, February 2nd, 2019.
Judge, Mr. Sissel, he is working right now. He works in construction where he gets paid $100. He lives in Fort Lauderdale by himself. His monthly rent is about $450. Judge does not want to risk losing the job that he has, nor the apartment. We're going to be asking the court to not revoke his pretrial release. The new matter that he picked up is nonviolent in nature. It's not similar to the offense that he's currently out on. So at this time, Judge, we'll be asking for the court to consider releasing Mr. Sissel on pretrial on this new law offense. with random drug testing.
All right. As to case number 19-001-547 CF10A, Mr. Sisley is out on pretrial supervision for grand theft auto and driving while license suspended. I am going to revoke the pretrial. I will impose a bond on count one, $250, and count two, $250.
That's a good one.
As to the new arrest,
Judge, this new arrest appears to be a residue charge. It may ultimately be just charged as a misdemeanor rather than a felony.
right? As to the new arrest, on count one, the bond is $1,000, and there's a $250 that was previously imposed for the traffic KPS matter. He will be before his division judge on the misdemeanor case tomorrow at 9 a.m. Good luck, sir. Ian Douglas Pinkerton.
He's here, main judge.
Sir, you're before the court from one count of possession of cannabis 20 grams or less, and count two is possession of heroin. And the court does find probable cause.
Judge, we're going to be asking for the court to consider releasing Mr. Pinkerton on pretrial release. He's 25 years old, been here in Florida his whole life. He's looking for work. Judge, he just finished, he had actually an interview scheduled today at a car wash at 11 a.m., but unfortunately he missed that. He lives in Pompano Beach with his mother. Judge, we're going to be asking the court to consider releasing Mr. Pinkerton on pretrial release on his behalf.
Your Honor, I would just request, if the court is inclined to release him to pretrial, that it be with random testing. He was just released from state prison April of last year on multiple burglaries out of Broward, one involving a home. He was sentenced to 4 years in state prison.
Judge, we wouldn't object to the drug testing.
All right, I do find probable cause. I'll release Mr. Pinkerton to pretrial supervision with random testing. Yes. Good luck, sir. I'm gonna Next we have, Tyree McNeil.
He's here present, Judge, I mean.
Mr. McNeil, you're before the court for 1 count of grand theft auto, and 2 is obstruction by disguised person.
Judge, we're going to be asking the court to consider releasing Mr. McNeil if the court finds probable cause on standard pretrial release.
I would object. Mr. McNeil was arrested just 5 days ago on a not in custody 2 counts of felony criminal history. He and 3 co-defendants basically just smashed 2 Hollywood police vehicles that were decoying vehicles. $1,000 bond was released on the post-version and is now before the court possession of operating stolen vehicles.
All right, I do find probable cause. The bond, or the release conditions are, that the bond is $1,000, and then he's gonna be on level 2 GPS. Good luck, sir. Tommy Holcomb.
He's approaching, Judge. Coming up, Judge.
Mr. Holcomb is before the court for 1 count of grand theft, 2 corruption by threat of a public servant or family, and count 3 is a parole violation, which is a no bond hold. I do find probable cause.
Judge, I'm a little concerned about the probable cause on count 2.
What's up, buddy?
It says he attempted to influence the performance of the officer's public duty by saying, "I have something for you." Okay.
All right, so I find probable causes to count 1.
And I got 4 for this afternoon. Okay. Good, all right.
Judge, if I heard correctly, the court found no probable cause for count 2.
Right. All right, as to count 1, the bond is $1,000. There's a no bond hold for the parole violation. Mr. Holcomb should be going before the parole board shortly. Good luck, sir. Jeffrey Adams.
He's here, Judge.
Mr. Adams is before the court for 3 counts of felony capias, which are no bond holds and not for magistrate. And then count 4 is an out-of-state felony hold, which is also a no bond hold. Extradition court we're already on Tuesday, so Thursday or Tuesday of next week. And then my notes indicate that the 227 and 228, he'll be in court respectively. Good luck, sir. John Galloway.
Mr. Galloway, come on up.
Mr. Galloway, you're before the court for 2 counts of distributing or delivering cocaine. And count 3 is trafficking of cocaine 20 grams or less. The court finds probable cause. That's the bond.
Judge, I'm going to be asking on count 3 for the court to consider reducing it from $15,000 to $5,000. And the main reason is, Judge, I believe this is his first time being arrested. He's 30 years old, been living in our community for the past 10 years. He's the sole provider of his family. He lives with the mother of his child and his daughter. He's working at a company called Shelby Erectors, in which they specialize in building bridges. He's been there for about 3.5 years, making about $21 an hour. He lives in Hollywood in the apartment that they've been renting at for about 2 years. Their monthly rent is about $1,300. So, Judge, based on strong ties and the first time being arrested, I'm asking for the court to consider reducing count 3 from $15,000 to $5,000 bond.
All right, the court does find probable cause.
Yes, and that the bonds be kept in place. It would appear Mr. Galloway is actively involved in drug dealing. These are 3 separate deals within approximately a 3-week period, the last one involving a trafficking amount. And it is true he has no criminal history, but even so, if convicted, he faces a 3-year minimum mandatory prison sentence on count 3.
Finding probable cause, the bonds, count 1 and 2 will remain at $2,500, and I will impose a $5,000 bond on count 3. Good luck,
Thank
sir.
you.
Jamal Myers.
Judge, medical reset.
Okay. John Vickers.
He's approaching, Judge.
Okay.
He's here, Judge, President May.
Mr. Vickers is before the court for 1 count of burglary of an unoccupied structure unarmed, and count 2 is a petty theft, 2nd degree.
Your Honor, he's currently out on felony petty theft for case number 180100049 CF10A. We're requesting that his pretrial is revoked.
All right, I do find probable cause on the new case. So,
Judge, right now, Mr. Vickers advised me there's no one that can afford to post his monetary bond. I realize he's out on a felony petty theft. Judge, at this time, we're going to be asking the court to consider raising the level of supervision and not imposing a no bond hold on Mr. Vickers. I believe he's out on standard pretrial. We're going to be asking for level 2 on Mr. Vickers' behalf. You've been out on it for 6 months? Judge, he informed me he's been out on pretrial for 6 months.
Your Honor, I'm going to be requesting a $10,000 bond. I know it's listed as a structure, but it's clear from the allegations that this was someone's home that he broke into and stole their TV. He's out on a felony theft offense. In 2007, he was convicted of attempted burglary of a dwelling and grand theft. He was sentenced to 10 years state prison, both as a habitual offender and a PRR offender. He was released from state prison November 16th of 2017. In 2007, burglary of a conveyance, 10 years habitual offender. 2007, attempted burglary of a dwelling and grand theft, 10 years state prison as a habitual offender. 2002, burglary of a conveyance and grand theft, possession of burglary tools, 5 years state prison. 95, burglary dwelling, dealing in stolen property, grand theft, 6 years state prison as a habitual offender. 95, burglary of a dwelling, grand theft, possession of burglary tools, 6 years state prison, habitual offender. So it would appear, Your Honor, that since 1995, he has spent a large majority of his life in state prison for breaking into people's homes, into people's cars, and now stands before the court today breaking into someone else's home.
Judge, the last thing I wish to say, and speaking of Mr. Vickers, he said he's been out on pretrial. I believe this is the first time he's violated pretrial. He's been going to court numerous times. I believe he actually has a court date this Thursday. I'd ask you not to take any action if certainly pretrial wants to submit a warrant, or the prosecutor assigned to that division wants to make a motion, they can certainly do so. But at this time, I'm asking for the court to consider level 2 pretrial for Mr. Vickers.
That's going to be denied. Case number 18-010-049, CF10A. Mr. Vickers is out on pretrial release for felony petty theft. I am going to revoke the pretrial. I'm going to impose a bond of $500 as to that case. On the new charge that's before the court, it's burglary of an unoccupied structure unarmed. Allegations here that he stole a neighbor's TV and tried to sell it. I'm going to impose a bond of $5,000.
I would just request no victim contact.
No victim contact.
Thank you.
Good luck, sir. Daniel Vidrine.
He's approaching, Judge, your main. Come on in, sir.
Mr. Vidrine, you're before the court for one count of possession of heroin, and the court does find probable cause.
Judge, we're going to be asking for the court to consider releasing Mr. Vidrine on standard pretrial release. He's 27 years old, been here his whole entire life. He is going to school right now. He goes to Dave Thomas, where he's getting his GED. Also, Judge, he lives in Pompano Beach with his uncle. His uncle works at a hotel in housekeeping and says cannot afford his bond. So that's why we're asking for pretrial release on Mr. Vidrine's behalf.
Your Honor, I would be objecting to that. I'm showing that he is currently on probation until September 6th of this year before Judge McHugh for domestic violence battery.
All right. So I do find probable cause. I am going to leave the bond in place at $1,000. Good luck, sir. Darian Geethers.
He's here approaching, Judge.
Sir, you're before the court today for one count of driving while license suspended. I do find probable cause. As the parties wish to be heard as to Mr. Geethers' bond.
Yes, Judge. And speaking of Mr. Geethers, from what he informed me, basically he hasn't been arrested on a driving while license suspended for over 20-something years. He's 43 years old, been here his whole entire life. At this time he is working. He works in waste management where he's been doing that for 3 years, but unfortunately, due to an accident, he's not working. Right now he's going through the process of filling out paperwork to go through workman's comp. He lives in Coconut Creek with his mother, and his mother's on a fixed income. She's elderly and on Social Security. So, Judge, right now he's not in financial position to post his monetary bond, and that's why we're requesting the court consider an ROR or release Mr. Geethers on standard pretrial release.
All right, I'll release Mr. Geethers on his own recognizance. Good luck, sir. Danielle Giuliano.
He's here, present, Judge.
Mr. Giuliano is before the court for count 1, possession of methamphetamine. Count 2, possession of hydrocodone. Count 3, possession of heroin. Count 4, possession of drug paraphernalia. Count 5, tamper with or fabricating physical evidence. Counts 6, 7, and 8 are traffic violations, which are not for magistrate. Counts 9 and 10 are felony violation of probation. The court does find probable cause. I am going to leave the bonds in place. My notes indicate that Mr. Giuliano should be before the felony presiding judge, 227 at 8:30 a.m. Good luck, sir. Antonio Hernandez,
I believe he's still on medical loan, Judge.
still on medical loan. Ernest Montez,
Medical reset, Judge?
okay. And how about Mr. Ayub? A-Y-O-U-B, Aid,
No problem, Your Honor.
North Broward. All right, good morning, sir.
Good morning, Your Honor.
You're before the court for one count of retail theft. Count 2 is false owner info for pawn items. Count 3 is dealing in stolen property. Count 4 is robbery without a firearm or weapon. And then count 5 is grand theft.
Judge, I'm going to ask the court to consider reducing the bonds for Mr. Ayub. Can count 1 from $3,500 to $1,000 and count 4 from $3,500 to $1,000. He's been living here 22 years. He's been living at the same location for the last 10 years. He lives with his mother. He's been a restaurant worker. He works as a cook. He's had the same job for the last 4 years. The bonds as they're currently set are a little bit out of his reach.
Your Honor, I'm actually going to be requesting the court keep the bonds on 1, 2, 3, and 5 in place. I'm going to be requesting a $15,000 bond on 4, pretrial release of the GPS. Frankly, I don't know that there's, without these bonding conditions, I don't know that there's anything to ensure either the safety of the community or property in the community. Mr. Ayub is currently out on a $1,000 bond. He was arrested February 9th for grand theft, and that was at a Lowe's in Pompano Beach. He also has a pending petty theft in county court. In 2015, he was convicted of felony credit card fraud, illegal use of scanning device, unlawful possession of personal ID. In this case, we had his co-defendant yesterday, Mr. Ayub, as so far to threaten the manager at a Petco, bodily harm, and to threatening to punch the manager in the face and shoot him if he didn't move out of their way, allowing them to flee the Petco.
No.
Don't say anything about your case, sir.
Considering these actions were committed after he was released on the pending grand theft, I have no confidence that he will not continue to commit criminal activity without the proper bond and release conditions set.
All right, I do find probable cause. And, allegations are concerning, and I am going to impose a bond. Count 1 will remain at $3,500. Count 2, $1,000. Count 3, $3,500. Count 4 is going to be $10,000, and count 5, $1,000.
Mr. Ayub, your co-defendant has a total bond somewhere in the area of $8,000. She's still in custody.
And that's on count 4. There's it's also a level 2 GPS.
So for me,
Yes.
I got level 2.
Yes.
Does my
On the
coach
case. On the case. I don't know, sir. She's not before the court this morning. I don't know on the whole case. Yes. Nathan Kemp. Yeah.
I think he's still on
Medical, Judge?
He's on a medical research. Okay. Joaquin Dos Santos.
Paul Ryan, maybe?
Is there Mr. Dos Santos?
It's definitely not Mr. DeSantis.
No. Does North Broward have Joaquin, Joaquim, last name Dos Santos?
I'm showing Paul Ryan, Your Honor.
Okay.
Your Honor, and also, just to let you know, in case you want to resend for the PM, I'm looking, when he first came through, he needed a Portuguese interpreter.
Oh, all right. So, is Mr. Even if he's not there right now, is he at Paul Ryan? Dos Santos, last name.
No. He's got no bond holds in an immigration. He was arrested on, no.
All right, we'll reset him till the afternoon because I also believe that he needs a Portuguese interpreter. So, okay, to be safe, we can do it tomorrow. Reset it for tomorrow.
He has a no bond hold, Judge, so I don't think it's.
Is he represented by the Public Defender's Office? Well, we'll reset it till tomorrow.
We're setting it for tomorrow. So.
Okay. We'll reset it till tomorrow. Thank you. Jason Gallagher.
He's here at Main, Judge, approaching.
All right, Mr. Gallagher is before the court. It's a KPS for a change of charge.
Yeah, Your Honor, it was changed from one type of fleeing to another. Your Honor originally set bond at $1,000.
Okay.
With we put a GPS level 2 on all the 5 counts.
I'm sorry. Okay, so I'll leave it at the same bond and release conditions. It was 1,000 with GPS.
Level 2, yes,
Level
Your
2.
Honor.
Okay.
Your Honor wrote an acronym. I don't know what the acronym is for. It says SPTR.
I did?
I think so, yes.
Standard pre-trial.
Oh, yeah.
All right, so it's $1,000 with standard pre-trial.
Use that. It's a new one.
Judge, considering he has no bond hold, I believe out of Palm Beach, nothing to add from the defense.
Okay, thank you. Terry Murphy.
Judge, if we can put on brief recall, he's coming.
Okay. All right. There are a number of municipal ordinance matters that I don't know if we were trying to see if we could get someone covering for Mr. Shade, but
You get instruction.
I really would prefer if someone is here for these persons. Yes.
Mr. Gallagher, did you do standard pre-trial? Previously,
Whatever the previous conditions were. No, Mr. Linder was asking me, but I don't know. So whatever the previous conditions were, we'll leave it. Mr. Reedy, by any chance, did you have a cell number for Mr. Shade? Somebody gave it to me yesterday, but I didn't write it down.
Yeah, I think I do. It's 954 728 3477.
All right, let me go off the record a moment. You're trying to see if what? No, don't worry. I spoke to his office. Yes. All right. We're back on the record. Yes.
Your Honor, when you get a chance, Terry Murphy is here as well.
Oh, okay. All right. Mr. Murphy. Mr. Murphy, you're before the court today for possession of a stolen credit card. Count 2, loitering and prowling. Count 3 is unauthorized possession of a blank or forged driver's license. And count 4 is a felony capious matter, which is a no bond hold. On that case, I do find probable cause as to the other counts. And I'm gonna leave the bonds in place. Count 1, $1,000. Count 2, $25. Count 3, $1,000. Count 4 is a no bond hold, and you should be before your division judge tomorrow. Good luck, sir. All right. Let me call these cases Jennifer Jones. Where was she again? At North Broward? Jennifer Jones.
Yeah, she's at Paul Ryan.
Oh, Paul Ryan. Thank you. Yes.
And she's also, no, never mind, sorry.
All right, Ms. Jones, you're before the court today for a municipal ordinance matter on a trespassing charge. You failed to appear in court on February 14th. What do you wish to do with your case, Ms. Jones? Turn the mic on.
Hello?
Yes, I can hear you.
I would like to resolve it.
All right. If you wish to resolve your case, Ms. Jones, the sentence will be adjudication and time served. All right. You got to turn it back on and leave it on until we're done.
Yes?
Okay. Don't touch it until we're done, okay?
Oh, it was on there. Okay.
All right.
Okay.
All right. Ms. Jones, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right. You can put your hand down. Ms. Jones, do you understand the proceedings we're in today?
Yes, ma'am.
And is anyone forcing you to resolve your case?
No, ma'am.
Do you need more time to speak with an attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
Yes.
All right. What plea do you wish to enter?
No contest.
All right. I accept your no contest plea, find that it's freely and voluntarily given, and I sentence you to adjudication and time served. Good luck, ma'am.
Thank you.
All right. Robin Simons.
North Broward.
All right. Ms. Simons, you're before the court for municipal ordinance matter, and I find probable cause. What do you wish to do, ma'am?
I'll resolve the case.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Ms. Simons, do you understand the proceedings that we're in today?
Yes.
And is anyone forcing you to resolve your case?
No, Your Honor.
And do you need more time to speak with an attorney?
No.
Are you under the influence of drugs or alcohol?
No, I'm not.
Have you ever been treated for a mental or emotional illness?
No, Your Honor.
And do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to immigration changes?
Yes, Your Honor.
What plea do you wish to enter, ma'am?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given. Your sentence, ma'am, will be adjudication and time served. And my advice to you would be to find out how you can get one of those safety vests and a certificate on the panhandling, so you won't have to come back to court on these kinds of types of charges. Good luck, ma'am.
Thank you, Your Honor.
James Terrell. James Terrell.
Broward, Your Honor.
All right. Yes.
He's also another one that was in custody at the time.
Judge, I believe Mr. Terrell just went out to the restroom and he's going to be coming back in shortly.
No,
he's in North Broward.
He's at North
Oh,
Broward.
then it's another gentleman.
All right. All right. So, Mr. Terrell, you're before the court for an ad charge of a misdemeanor capias on a trespassing charge, but I've been told that you were in custody on February 14th at the time that the capias was issued. Is that correct?
Yeah.
All right. So I'm going to I'll dismiss this capias. I don't know if you're being held on something else. All right. No. Yes or no? Yes. All right. Okay. So as to this capias on this trespassing charge, I'll dismiss that because you were in custody at the time. All right.
All right. All right.
Good luck, sir. Madam Clerk, what do you need me to do with that? Yes. Okay. Gilbert Pineda.
Conti.
Okay. Gilbert Pineda. Do we have Gilbert Pineda? Conti? All right, then we'll go to Timothy Odom.
He's here at Main, Judge.
Judge, Mr. Pineda
Yes?
is downtown.
Oh, okay. So what we setting for tomorrow?
Yes, please.
All right, Mr. Odom,
Hi, Ms. Powell.
here we are again.
Yes, ma'am. I would like to take this to trial, resolve this at trial, maybe be released on my own reconnaissance, because what I did yesterday was not a violation, in my opinion. I'm walking down the sidewalk. I am not flying a sign. I don't even have a sign. And they said that I was asking people for money, and which I was not doing it. The streets are crowded, the windows are rolled down. We talk to a lot of people out here.
Mm-hmm.
I am a veteran, and people recognize me as being such. And all they did yesterday was ride around in a van for 5 hours, picking up homeless people for just whatever different reasons. I was one of the first ones, and I wasn't flying a sign.
All right. Well, you've
Take
been
this to trial.
you've been here before, where you've said where you've said it's me. I'm gonna take a plea, or the other time you told me something else. So, if you want to take this to trial, I'll ROR you on these counts. But did you apply? Well, Mr. Shades is not here today, so you've got to pay attention now to your mail so that you know when to come to court if you want to fight this case. Good luck, sir.
Thank you, ma'am.
All right.
Hey, have a good day, Ms. Powell. Yes, sir.
I'll make sure. That's what he got, that's what the court got. Yes. I will call it first thing tomorrow morning.
All right. Junius Dyson.
Morning, ma'am.
Good morning, Mr. Dyson. You are also before the court for municipal ordinance matter. And the court does.
Yes, ma'am. I choose differently. I choose to resolve my matter today.
Okay.
But I do agree with Mr. Odom that I was also one of those people that was just picked up on the street.
Okay.
But I can't. My house is insecure, and my animals are insecure. I'm asking the court for expedited release.
All right, Mr. Dyson, if you want to resolve your case today, it'll be adjudication and time served.
Adjudication. What does that mean, ma'am?
That means that there's a conviction on your record.
Okay, I don't owe court costs, all right?
Yes, there'll be court costs, but I can give you.
I don't. Can I ask for adjudication with help?
Well, I have to impose the court cost, but I can give you 6 months to pay the court costs. It's $78.
Okay, I'll live with that.
All right, please raise your right hand. You swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. Mr. Dyson, you understand what's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
Yes, ma'am.
Are you taking any medication today that
No,
would
ma'am.
affect your decision making?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
I am a citizen, ma'am.
All right, sir, what plea do you wish to enter?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence, sir, will be adjudication and time served. I will give you 6 months to pay your court costs. Good luck.
Thank you, ma'am. Could I ask for expedited release?
You should be out soon.
I need to get home today.
What does that mean? What does he want me to? You'll be out today.
Yeah, I just have my animals in my house
Right.
insecure.
You'll be out
I just
today.
need to-
You'll be out today,
Thank
sir.
you. Thank you.
Timothy Kennedy. Mr. Kennedy, you're also before the court for a municipal ordinance matter. I do find probable cause. What do you wish to do, Mr. Kennedy? What do you wish to do, sir?
Excuse me?
You are before the court for a municipal ordinance matter. Did you hear that?
Yes.
And I do find probable cause. And my next question is, what do you wish to do with this case today?
Resolve it.
All right, Mr. Kennedy, if you want to resolve your case, it'll be adjudication and time served. Do you wish to do that?
Yes.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you may put your hand down. Do you need more time to speak with an attorney?
No, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for mental or emotional illness?
Yes, but I'm okay.
Okay. And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
Very good.
Okay.
Yes.
What sentence do you? What plea do you wish to enter?
No contest.
All right. I accept your no contest plea, Mr. Kennedy, and your sentence is adjudication and time served. Actually, it's for, I'm going to change the sentence to withhold adjudication and court costs, okay? I'll give you 6 months to pay the court costs. Good luck, sir.
Thank you very much.
You're welcome, sir. Christopher Glass.
Yes, Your Honor.
Mr. Glass, you're before the court today for 2 municipal ordinance matters, and the court does find probable cause. What do you wish to do, Mr. Glass?
I wish resolved today, ma'am.
All right. The sentence will be adjudication and time served. Is that
Yes,
what you
ma'am.
wish to do?
Yes.
Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. Is anyone forcing you to resolve your case?
No, ma'am.
And do you need more time to speak with an attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
Yes, ma'am.
All right. What plea do you wish to enter?
No contest.
I accept your no contest plea. Find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck, sir.
Thank you.
All right, take care. I believe that brings us to the end of our docket, our morning docket. And so, thank you, everyone, and I'll see you this afternoon.
Thank you.